So recording now. So last meeting we stopped with the distinction between industrial partner and capitalist partner. So we will move on now to distinguishing partnership from other contracts. And I believe I have also explained this in passing last time, the difference between partnership and joint venture. But this time, let's look at some other points of distinction. So, partnership operates with firm name and legal personality, while a joint venture operates without a firm name and legal personality. So, it's like just more siya og, quote unquote partnership but temporary and for a specific purpose. So, wala siya legal personality on its own, while a partnership has a legal personality of its own. Then, for partnership, it generally relates to a continuing business of various transactions of a certain kind. So, for partnership, you can um, you can enter into several transactions as long as within the scope of your primary purpose and secondary purpose of your business. But for joint venture, this is limited to a single transaction. Like for example, in the construction of a bridge, and then two companies entered or two or more companies entered into a joint venture. So that joint venture is only for the purpose of the construction of the bridge and nothing else. But for partnership, you can practically enter into different uh, transactions that are incidental to the conduct of your business for your partnership. Okay, so for partnership, corporations may not enter into a partnership, but for joint venture, they may enter into joint ventures. So, by definition, a joint venture is an agreement between two parties to enter into a commercial undertaking. It may fall under a partnership with a limited purpose. So, in a sense, it's like a partnership, but again, a joint venture is only for a limited purpose. So under the Philippine law, a joint venture is somewhat like a form of a partnership, and therefore the relationship between the parties that are part of the joint venture will be governed by the same laws of partnership. But again, we have to take note that a joint venture does not have a legal personality of its own as compared to a partnership. Next, we will distinguish partnership from co-ownership. So partnership is generally created by either express or implied contract, while a co-ownership is generally created by law and may exist even without a contract. So remember what we discussed last time, that partnership is actually a contract, diba? It is a contract that means that the elements of a contract must be present. So, katong COC ninyo. But for co-ownership, it may exist even without a contract because sometimes a co-ownership is created by law itself. Meaning to say, even though the co-owners do not really intend to become such, no, dili sila ganahan mahimong co-owners, but because of a certain provision of the law which treats them as co-owners, then there will be a co-ownership created. So even without meeting of the minds of the co-owners, when there is a provision of the law that says, oh, kamong duha or kamong group of people, you will be considered as co-owners with respect to this particular thing. So you have no choice but to treat each other as co-owners. Okay, so with respect to a separate juridical personality, we all know that a partnership has a separate juridical personality apart from its partners. So again, if there are two partners and they created one partnership, there are actually three persons, no? The two partners and the partnership created. So the partnership created is now considered a person separate from the partners. But that is not true for Again, I also mentioned this last time that is not true for general professional partnerships. And so in general professional partnerships, these are partnerships created for the purpose of the exercise of profession. Okay. Then while co-ownership has no separate juridical personality, therefore, if there are two co-owners and they have a co-ownership over a particular thing, then the co-ownership itself is not considered a person. So the number of persons with respect to co-ownership remains equal to the number of co-owners. So if there are two co-owners and one co-ownership, ang number of persons are only the two co-owners. Okay. So the purpose of partnership is to obtain profits. We also have to remember the definition of the partnership. No, they are contributing something to a common fund for the purpose of dividing the profits among themselves. Again, we say that there is no partnership that is not for profit. All partnerships are for profit. So the purpose nga nung mag-create mo og partnership is for you to earn money, right? To obtain profits. While for co-ownership, that is not mainly the purpose. The purpose is to enjoy a thing or a right. So for example, very typical example. You want a car. Let's say, ganahan mo magsigi og laag sa imong boyfriend, and then but wala pa mo'y car, and then individually you cannot afford a car. So you decided between yourselves to pool your money to buy a car. So the car is now co-owned by the two of you. So, but the purpose of having a co-ownership over the car is not really to obtain profits, no, not to earn money from it, but rather for you to enjoy it together. No, so there is common enjoyment of a thing or right. And then the life of the partnership or the term of the partnership. Term depends upon the lifetime of the partners. This is for partnership at will. No? So, for example, if in your partnership contract, you did not specify for how many years mo exist ang inyong partnership. So, if you did not specify, then the law will assume that your partnership is a partnership at will. So, because partnership also, if you remember, this is personal in nature, such that if one person ceases to become a partner for whatever reason, be it death, for example, the other partner ceases to become a partner because he died, then your partnership will dissolve. The term of your partnership will end. Okay, but for co-ownership, there are instances that the co-ownership will subsist despite the death of one co-owner. So, for example, and again, you can also specify that your co-ownership will last for a particular period. However, there is a specific provision of the law which says that ang maximum lang yun daw nga term as a general rule sa co-ownership is maximum 10 years. Because actually, based on my readings no sa Civil Code of the Philippines, it appears that the law actually disfavors co-ownership. Pag dili kaayo ganahan si law o co-ownership, because since it actually puts a deadline nga dapat if mahuman na ang 10 years, you should already partition the thing that you are co-owning. So, not more than 10 years, no, an agreement to keep a thing undivided for more than 10 years is not allowed. So that means maximum for 10 years co-ownership. After that, you need to do partition. Say pasabot sa partition, bahin-bahinon na ninyo. But with respect to a car, di ba, dili man siya physically divisible. So what you do for those co-owned properties that are not physically divisible no lain kay tungaon ninyo ang car i-half ang front imuha ang likod yaha no so di man siya pwede so for co-owned properties that are not capable of physical division, what you will do is to sell it and then divide the proceeds between or among the co-owners. But there is an exception here, but may be extended. This actually pertains to that provision of law that favors the wish of a decedent. So, for example, you inherited a property together with other heirs, no? Nga, for example, imong lolo dito sa iyang last will and testament nga, I am leaving my farmland to all my grandchildren. So, kamong tanan mga apo, you are now considered co-owners of the farmland. And then if moingon si lolo nimo dito sa last will and testament nga, this farmland shall be co-owned by all my apo, grandchildren, for a period of 15 years. So, di ba nilapas siya 10 years, which is prohibited by law. But there is a special consideration for properties that are inherited by or through a will. Now, will executed by a decedent. So, for that purpose, ang maximum year is 20 years. And after which, you really need to partition your property. Okay? So, but for partnership, there is no such provision under the law nga dapat kutubra mo 50 years, dapat kutubra mo 20 years. No, walay specific years ang giingon sa law. You can do it forever if you want, but of course, forever no, it's a very long time. So eventually, one of your partners will die. So if one of your partners will die, then the term of your existing partnership will end, and then you have the option to continue it, but this time with the surviving partners na lang. Okay, we have a question here. Okay, reside until 50 years? No, only 20 years lang jud. As a general rule, 10 years lang jud. And then exception is with respect to katong inheritance nga maximum of 20 years lang jud. Okay, but for example, no that is what is provided by law. But in reality, like for example, if there is a co-ownership that has already been existing for more than 10 years and then wala pay partition, you as a co-owner actually has the right to sue your other co-owners if they will not agree na i-partition ninyo ang property, because you should highlight that provision of the law which says that maximum 10 years lang jud ang co-ownership, such that if dili mo sugot ang imong other co-owners to partition the property, you can sue them in court because you now have a cause of action against them. But again, as a general rule, 10 years. Good morning, Miss. Ang co-ownership kay ma-extend nimo multiple times. No, you cannot actually extend it. So mo na siyang after 10 years, you really have to partition the property. So you can partition the property, and then after which na ini-partition niyo sa property, you may use the proceeds sa mga ang kwarta nga imong nakuha sa partition, you can use the proceeds in sa mga co-owners and then pull it together again to own another property niya, i-co-own the po ninyo. Then Miss, if we have another question. Then Miss, if mamatay ang mga co-owners niya, isaray mahabilin Miss, iyahan na tanan ang property? No. Okay, no. That share of the co-owner who died will be transferred to the heirs of that co-owner. So dili ma-transfer dito sa nahabilin. Kung swerte kayo siya, no? Siya pa ang wala namatay, siya pa jud nakakuha sa share. No. Okay, so ang share sa co-owner nga namatay will be transferred to that co-owners heirs. Okay? Sige, but again, we focus lang on partnership. Ang here lang ato lang distinguish lang si partnership and co-ownership. Okay, next, for partnership, there is mutual agency between the partners. For partnership, there is mutual agency between the partners, while in co-ownership, there is no mutual representation among co-owners. What this means is that for partnership, they are agents of the partnership itself, no, and then they can act. Each of the partners have their have the rights and obligations of an agent with respect to the partnership, such that one act of a partner binds the other partner and the partnership itself, correct? But here, for co-ownership, the act of one is not considered the act of all. So therefore, for example, no, one co-owner approaches another person and says, ganahan ka palito ni nga yuta. For example, you own katong farmland nga inyong gi-inherit sa inyong lolo. Kamo tanan grandchildren ang co-owners of that farmland. And then one of the apo approached another person, a third person, and says, ganahan ka nga palito ni nga farmland. Ang price ani kay, let's say, 10 million. And then that third person agreed to buy it. Will it bind the other co-owners? The answer is no. Okay? So the co-owners, one of the co-owners has no right to represent the other co-owners, such that in decisions like this, for it to bind the co-ownership itself, it needs unanimous decision, no, of the other co-owners. But for partners, since there is mutual agency, the act of one is considered the act of all. Kung unsay gi-enter nga transaction sa isa ka partner, it will bind the other partners, and ultimately it will bind the partnership itself. Okay? So for partnership, dili na mo kailangan mananghid pirmi. As long as ang inyong transactions nga gi-enter into is within the ordinary course of business. Okay? But for co-owners, you cannot act alone. Okay? You cannot act alone. Whatever your acts are, it will only bind you, and it will not bind the other co-owners. So in my previous example, nakatong one of the co-owners approached a third person and sold the co-owned property. So what will happen now? The sale is considered void. Void with respect to the shares of the other co-owners. It means that the sale is valid with respect to the share of the selling co-owner. So kay usara man siya ang nibaligya, ang iyaharang share kumbaga ang nabaligya. Dili ang tibuok farmland. Ang iyaharang particular share of that farmland. The other shares, no, nga gi-own sa other co-owners, void to siya. Right? Next, the effect of death or incapacity. So for partnership, death or incapacity of a partner dissolves the partnership, while death or incapacity of a co-owner does not dissolve the co-ownership. So mo to siya atong i-relate sa question sa inyong classmate kanina nga. What if one of the co-owner dies? So if one of the co-owner dies, his or her share will be transferred to the heirs, and then the heirs will become the co-owner together with the other surviving co-owners. So the co-ownership itself will not be dissolved. However, the partnership, when one of the partner dies or becomes incapacitated, the existing partnership will be dissolved. But the other surviving partners actually have the discretion whether to continue it, but this time without the name of the dead partner. We have a question here. Is that legally called as succession? Yes, yes. So having the rights of succession. No? So mo na siya actually ang distinction sa partnership and corporation. So for corporation, if one of the shareholders die, the corporation will survive. and the share of the shareholder who died will be transferred to the shareholder's heirs. So if you remember the definition of a corporation, no, a portion of the definition says having the rights of succession. Okay, so same lang na siya with co-ownership. Na siya right of succession. Okay, for partnership, a partner cannot dispose of his interest so as to make the assignee a partner without consent of others. So for example, no, you have 3 partners in your partnership, and then one of the partners says, kapoy naman ko magsige business, ay ganahan naman lang ko mahimong caveman. Ang akong share ha, akong ibalhin ni kuan ni Mr. A, siya na lang ang inyong partner in lieu of me. Can you do that? No. Because again, you always go back to the fact that partnership is actually personal in nature. When we say personal in nature, that means the partners have the liberty to choose kinsa ilang ganahan nga partner. So if ang imong assignee is someone na dili sila ganahan, you cannot force them to admit that person as their new partner. So for you to make your assignee a partner, kay gi-assign man nimo niya ang imong interest kay di lagi kaganahan. So for that assignee to become a partner, it needs consent of the other partners. While for co-ownership, a co-owner can dispose of his share without consent of others. Like in my example a while ago, one of the apo sold his share to a third person. So dili na siya pwede, dili na siya kinahanglan mananghid sa other co-owners nga, okay ra ninyo nga akong ibaligya ang akong share. No, dili na kakailangan o consent or permission from the other co-owners. So once you sold your share as a co-owner, that someone else will automatically become a co-owner, whether they like it or not. Okay, but for partnership, since partnership is so personal in nature, such that partners can actually choose who they want to become a partner pod sa ilang partnership, then ang assignee will not automatically become a partner. He will only become a partner once the other partners consent. Okay, here we have partnership versus corporation. So both of them has a juridical personality that is separate and distinct from its individual members. But again, take note, this is not true for general professional partnerships. So if we relate that to tax as well, for tax, a GPP is not taxed, but rather the partners will be taxed. So kay nga ito kay ang GPP wala dai siya kaugalingan nga juridical personality. For partnership and corporation as well, they distribute their profits to those who contributed to the business. But for corporation, this is only true with respect to a stock corporation. But non-stock corporation, wala siya profits nga i-distribute. Ha? So only stock corporations. But they are the same in a sense with partnership because whatever profits that they have earned, they will distribute it to those who contributed. So for partnership, they will distribute the profits to the partners, while for corporation, they will distribute the profits to the shareholders. Okay, and then they are both taxed as a corporation. So if you were able to study the National Internal Revenue Code, I think you can see there under Section 17 onwards, now that a partnership is also taxed as a corporation. Partnership is created by agreement. Again, balik-balik na gid nato syaro naman sad og ma-miss out pa ni nato sa exam, no? It's created by agreement, meaning COC kaning sa elements sa contract. You agreed, you had a meeting of the minds that you really want that you want to create a partnership. While a corporation is created by law or by operation of law, because mere agreement is not enough, no? Nag-agree mo among yourselves, oy, let's make a corporation, agree ka o agree ko, and then okay na ba na, dili pa. You need an authority by law for your corporation to start existing. And how is that made? Through your application sa SEC. Okay? So you need to apply for a registration in the Securities and Exchange Commission. And once you have complied with all the requirements listed by the Securities and Exchange Commission, that's the time that the Securities and Exchange Commission will issue you a certificate of incorporation. The issuance of the certificate of incorporation by the SEC marks the beginning of the personality and life of the corporation. So pag-issue ni SEC sa Certificate of Incorporation ninyo, diha pa na-create ang corporation. And that certificate, no, Certificate of Incorporation, issued by the SEC is considered as the authority given by the law. So it is created by law. Your corporation is created by law through the issuance of the Certificate of Incorporation. Thus, prior to the issuance of the Certificate of Incorporation, your corporation has no legal personality yet as compared to partnership. No nga, the personality and the existence of a partnership starts upon meeting of the minds. Okay, so here, this is not actually ko anday wala din na ako wala na ako na update. For partnership, it involves at least 2 persons. For corporation, wala na nino, lahi naman ang rule na to sa revised corporation code. Here, you can do corporation sole. Ang corporation sole is with respect to kanang mga religious societies. But we also have this OPC. Ang sabi ng OPC, one person corporation. So, even though wala kay kauban, you can now create a corporation, and that corporation is what we call your OPC, one person corporation. But if you have other incorporators, you can also establish a corporation. So wala na ni siya, requires at least 5 incorporators. Okay? Then ayaw mo kalibog sa corporation sole o sa OPC. Okay? Lahi na siya. Although more siya og parehas paminaw no, corporation sole, that means usara. Then OPC, one person corporation, usara sad. But lahi na sila. Okay? Lahi silang purpose. Corporation sole, gani. Una-unaan dayon ng the Roman Catholic Church. No? It is headed by the Pope. So, mo siya corporation sole in that sense. Usa ra gyud actually ang murag quote-unquote owner. Okay? But ang OPC is ikaw ra gyud usa. It is private in character. No? It doesn't really do any special purpose like religion or charitable whatevs. You can create an OPC for whatever purpose, except also for whatever purpose, except practice of profession. Kaya again, if you do practice of profession, bawal corporation. Even OPC, bawal. So dapat either mag-sole proprietorship ka or mag-partnership ka for the exercise of profession. Okay, so muna akong giingon ganina, no? For partnership, the personality commences from the moment of execution of the contract, meeting of the minds. While for corporation, okay, except for GPPs, because again, the GPP itself has no separate juridical personality. Corporation commences from the issuance of the Certificate of Incorporation. And then, partnership can exercise any power authorized by partners, while a corporation can only exercise those powers given or conferred by the Corporation Code or by the corporation's articles of incorporation, and such as are necessary or incidental to the exercise of such powers. So in a sense, the powers of a corporation is limited, more limited, as compared to partnership. Because for partnership, the partnership can exercise any power, unlimited, no, as long as authorized by partners. But for corporation, it has no power to perform an act that is not authorized by the corporation code or by its articles of incorporation. Okay, for partnership, when the management is not agreed upon, every partner may act for the partnership. While for corporation, the management is vested in the board of directors or trustees. For partnership, partners are generally liable for partnership debts. So, diba, this is true in particular to general partners. Why? Because diba, for general partners, they can be liable even to the extent of their personal assets. But for corporations, the stockholders are liable only to the extent of their shares. So, dili makagukod si corporate corporate creditors sa personal assets ni stockholders or shareholders. And then we already know this, no? You cannot dispose as to make the assignee a partner without the consent of others. But for corporation, a stockholder has the right to transfer his shares without consent of the others. So, for example, if you own 5% of the outstanding capital stock of a corporation and you want to sell that percentage to another person, then you can do so without the consent of other shareholders. Let's say mananghid kas tanan, no? So you have the liberty to dispose. Then for partnership, the term depends upon the lifetime of the partner. We already know this. This one is also amended na, no? Perpetual existence na si corporation. So as a general rule, the life of the corporation is forever, no perpetuity, but still, the incorporators are given the liberty by our revised corporation code. They are given the liberty to still choose a life. So yun si law nga. Okay, from this point on, perpetual na ang existence sa mga corporation. But then what if di ka ganhag perpetual? Ikaw one of the incorporators ka, no? Di ka ganhag perpetual. Can you choose a specific life, nga specific years, nga 50 ra jud akong ganahan, 30 ra jud akong ganahan? Yes, you can do that. Okay? You can specify nga ganahan ra jud ka fixed term. But if you will not specify, as a general rule, the life of the corporation is already in perpetuity. Okay, so here for partnership, it may be dissolved at any time by one or all of the partners because again, partnership is personal in nature. So if dili naganahan, then you can immediately dissolve the partnership. But for corporation, it may only be dissolved with the consent of the state. Ang pasabot ani, if you want to dissolve a corporation, kailangan pa ka go through sa requirements na sad sa Securities and Exchange Commission. So the consent of the state is actually given by the Securities and Exchange Commission. So dili pwede nga siya nga ay dili na ta quit na ta. Dili pwede na. You need to go through a process, a formal process to dissolve your corporation. Okay. So what here we will look at the effects when parties come together intending to form a corporation, but no corporation is formed due to legal cause. So parties who had intended to participate or actually participated in the business affairs of a corporation would be considered as partners under a de facto partnership. Ang pasabot ani is, for example daw, ganahan mo maghimo og corporation, no? You intended to create or establish a corporation, but you were not able to follow the process, the legal process of the creation of a corporation. So wala mo nanghid sa SEC, wala mo na ngayo og certificate of incorporation from the SEC, and despite that, you still conducted your business. So you will be treated as a de facto partnership and not a corporation. And as such, you will be considered as partners. So you would be liable as such in an action for settlement of partnership obligation. So again, you will be treated as partners na, or your business will be considered a partnership and not a corporation. And parties who took no part except to subscribe to shares of stock in a proposed corporation do not become partners with other subscribers who engaged in business under the name of the pretended corporation and are not liable for action for settlement of the alleged partnership contribution. So therefore, katong mga persons nga kunuhay nagbayad para sa shares of stock nga supposedly corporation pero wala na hitabo ang corporation, kay nahimo na siyang partnership de facto, katong mga wala jud nag-apil-apil sa conduct of the business will not be made liable to third persons. Okay? Because you go back to the concept of partners by stoppel, no? These persons nga igo ra ni subscribe to shares of stock in a proposed corporation, they did not represent themselves to third parties nga in anime. Okay, so there is no stoppel on their part. So therefore, they will not become liable if there are any liabilities incurred by this supposed corporation. Okay, so I hope you understood that. And then we compare partnership with conjugal partnership of gains. So asa man ni nato nadunggan di ay si conjugal partnership of gains. So when you studied, ay, na ba mo tax? Not sure if na mo tax nga subject, but if you did have a tax nga subject, particularly katong transfer taxes nga topic sa estate tax, no? This has been discussed. This is the property regime that will govern the properties between spouses. Munang conjugal partnership of gains. So partnership again is created voluntarily, such that you cannot be forced to become a partner and create a partnership with another person. So kailangan na address COC, no? Meeting of the minds. So voluntary jud imong pagka become a partner and pagbuhat sa partnership. And then the partners could be of the same gender or opposite gender. The law has no requirement with particular na gender. But for conjugal partnership of gains, this arises in case the spouses which are of opposite sex, dapat ang spouses man and woman jud. This arises in case the spouses agree before marriage. It says here agree before marriage. Why? Because as a rule karon, no, if di mo mag-agree before marriage, ang inyong property regime between spouses is not anymore conjugal partnership of gains, but rather your property regime will be absolute community of property. So daghan kayo timan-an, no? So kung wa mo nagsabot daan before marriage, kung unsa inyong property relations sa kamo mag-asawa, automatic absolute community of property. So if ganahan mo conjugal partnership of gains ang mo-govern sa inyong duha, you need to agree on that before mo maminyo. And how will you agree on that? You need to execute a prenuptial agreement. Okay? So mo nang tinuod nga prenup. Ang tinuod nga prenup is sabot-sabot sa inyong property relations. Dili ka nang magpusing-pusing, no? Na murag artista. Di na mao ang prenup under the law. Ang prenup under the law is you, no, the future spouses, you deciding on sa inyong property regime. So again here for conjugal partnership of gains, you should agree this before marriage. Okay, so partnership is governed by agreement between the partners, while conjugal partnership of gains is governed by law. Di mo pwede makabut-buot na. Sige, conjugal partnership of gains ta, and then ang akong pasabot sa conjugal partnership of gains kay tanan yuta imuha, tanan auto ako, pwede ba na dili? Because there are specific rules that relate to the implementation of conjugal partnership of gains. This governed by law. You cannot change it. So once you have chosen conjugal partnership of gains, whatever sharing no specified by law, mao gyud na inyong i-follow. Di mo pwede magbuot-buot na. Di mo pwede magsabot-sabot nga imuhan kaning specific ako, imuhan ni, unya kani ako dili pwede. Whatever is provided by law, mao gyud na inyong i-follow. But for partnership, you have the liberty to um, agree on the terms of the partnership. Unsa inyong ganahan mahitabo sa partnership, pila inyong sharing, etc. Okay, so for partnership, it has a juridical personality. Again, this is not true for GPPs, while conjugal partnership of gains has no juridical personality. So therefore, for conjugal partnership of gains, ang persons involved, duha lang yun, ang spouses. Okay? Ang conjugal partnership of gains itself has no personality. Okay, partnership, commencement date may be stipulated. Pwede mo magsabot na. O sige, ang ato ang partnership magsugod siya January 1, 2023. Okay ra ka ani? Namingon po imong partner. Okay ra. So nanay meeting of the minds. Okay? So pwede mo magsabot January 1, 2023. Ang conjugal partnership of gains, since this involves marriage, no? Di mo pwede makabuot nga, mag-start lang ni January 1, 2023. No, because as provided by law, the commencement is on the date of the celebration of the marriage, and any stipulation to the contrary is void. So kung karon mo nagminyo, karon sad magsugod ang conjugal partnership of gains. Dili pwede i-defer ninyo to a later date or another date. That is not allowed. So if you really stipulated na later date pa, that stipulation is void. Then for partnership, the share in profits may be stipulated. Otherwise, in proportion to contribution. So, pwede mong magbuot, di ba nga, 50% imuha, 20% ako, then sa atong third partner is 30%. But if wa mo nagsabot, ang inyong sharing will be based on your contribution. But for conjugal partnership of gains, share in profits is equal. Dili pwede maingon si husband na, ako may mas kugihan, dapat 80% ako, ikaw kay sige kag cellphone di haspelay, 20% lang imuha. No, equal sharing jud. Okay? And for partnership, management is shared by all partners unless otherwise agreed upon. Like for example, lagi, let's say sa inyong partnership agreement, you agreed na si person or si partner number 1, siya ra jud ang magpadagan sa business. At kamo, wala ra. So that could be done. But for conjugal partnership of gains, the administration belongs to the spouses jointly, but the decision of the husband prevails in case of disagreement. Okay? So, medyo unfair man siya kay patriarchal man gud ang ato ang country, no? So, as a rule, you both have a say on how to administer your properties and all. But if in case of a mismatch sa inyong mga gusto, the decision of the husband prevails. Okay. I think mas okay siguro na if we turn on our cameras para rag na ay mas nila totong interaction. Although, sorry daan kay upata nakaayos diri. So, okay. Way panudlay og walay pa pamulbos. Anyway, if you can turn on your cameras, that would be much appreciated na para makakita po kung someone here na pastorya. Anyway, sanata. So administration belongs to the spouses jointly. So for example, namoy property no as husband and wife. And then ikaw asawa ka ingka nga muragwa naman ni nato gigamit nga property. Let's just sell this. Ito lang nang ibaligya. Nya. May si husband nga di ko ganahan nga ibaligya na siya. So kay di mo parehas og ganahan. Ang kinsa nga decision ang mo prevail. It will be the husband's decision. So give way. Wives, please give way. Attorney, I have a question here. Attorney, what will happen to the conjugal partnership of gains in case one of them wants to annul their marriage? So as part kay annulment is a judicial matter man, no? So you need to file a case jud in court. So if the judge will grant your petition for annulment of your marriage, then in the decision of the court is what na po dito ni judge ang partition sa inyong property. So ma-dissolve na sad ang inyong conjugal partnership of gains. So sa decision sa korte, makita nimo dito ang sharing ninyo. The, the house will be given to the wife, okay, and then the car will be given to the husband, and so na siya dito sa decision. Good morning, attorney. For conjugal, should the commencement be at the moment a marriage certificate is acquired, or during or after a ceremony? After yun, immediately after mahuman ang ceremony. Okay? Pero anyway, ang issuance sa marriage certificate is immediately after man sad sa ceremony. No? Kabantay mo na. After na, no? You may now kiss the bride. No? After na, paduulo na sila dito sa kuan sa table katong table sa tubangan ba sa pari dito magpinirmahay sila sa certificate of marriage. So on that day yun, on that day start na ang ilahang conjugal partnership of gains if na sila prenup agreement choosing conjugal partnership of gains. Okay, and then her partnership, a partner can dispose his or her interest in the partnership even without the consent of the others, while a spouse cannot dispose of an interest during marriage even with consent. So again, the conduct or the implementation of the conjugal partnership of gains is provided by law. So di mo pwede magbuot nga napulaan naman ko nimo uy yan sa di mo ba nga ako sad napulaan na sad ko nimo. Ang buwag na lang ta or kanang si kuan na lang si kanina lang nga girl ang ipuli nga wife pwede ba na dili even with consent. So if you want to dissolve your marriage, that is very 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 difficult to do. So although we have these annulment and nullity cases, dili siya sayon i-prove because the grounds as well for the annulment and nullity of your marriage are provided by law. So therefore, if wala mo ni fall under those circumstances nga gilista sa law nga valid grounds for nullity of your marriage or for the annulment of your marriage, then you cannot separate from your husband or wife despite the lack of love. No? What you could do is to maybe ask for a legal separation, which is lahi, dili na siya annulment. Ang legal separation, dili na siya annulment. So for legal separation, you are not allowed to remarry. But for annulment and nullity, you can remarry. But again, very, very difficult process and dugay pa kay mahuman. So wala pas 5 years. Miss, so that is why the prenup is very important regarding marriage po. Yes, especially for those couples ba nga medyo sensitive gani kay ang money or property issue. Like in the case of my friend, ang iyang boyfriend sa una kami husband naman niya karon, but iyang boyfriend is very rich, very very rich. But ang friend is so yang job is mukantara siya sa hotel, so of course gamay ra ang sweldo but the husband to be ang iyang boyfriend sa una is very rich, so daghan og businesses, daghan og properties, and so it became an issue with the family pod sa part sa husband. So basin daw kay di ba, of course if you have no prenuptial agreement, once you get married, what will govern the property relations between the spouses will be governed by the absolute community of property, which means that whatever is mine is yours, whatever is yours is mine. So tanan din yung properties isagol, and then half mo ana. So niingon man ang relatives sa lalaki nga. Basin, kwarta lang ang giapas. So, to prove also her sincerity na nga, love gid iyahang purpose for the marriage, they entered into a prenuptial agreement, saying that their property relations will be governed by complete separation of property. Okay, so you actually have option no nga ingon siya dito sa ilang prenuptial agreement nga tanan properties sa akong boyfriend minyo na namo iyaha ra gihapon dili ko manguha. So complete separate, although we are married, our properties will be under complete separation of property. And she made it as a condition sa iyahang boyfriend nga di ko magpakasal nimo unless mosugot ka nga mag-complete separation of properties ta para di ko ma-question sa imong relatives. So of course they entered into that and then they got married. So mana siya. Very very important ang prenuptial agreement kung issue kayo sa inyong properties. Okay, it's another question. Attorney, just like the annulment of Chris Aquino and James Yap, like even after separation, James Yap has a share of the property or income of Chris because wala sila ga prenup. Yes. So, na siya. If na isa ka dato o na ang isa kay kanang dili commensurate, dili equal ang ilahang pagkadato pa. So, mahimo siyang issue no. Although this is a very sensitive topic. What if you are really in love, no? But love in each other and then you would think pa nga di mo moabot sa point nga mag-away mo sa property, but just to ano na lang, like a precautionary measure nga, what if in the future wabi ka kay bro say may tabo, no? So what if mag-away you mo eventually, even though ang inyong love for each other for now is really burning, but in the future magod basin mahimo siyang issue. So muna siya, you can do a prenuptial agreement. And then once you decide, okay, we have a question here. Can that be changed to conjugal partnership of means? So once you have decided, no, prenup mo. Prenup, so that means before marriage. Pre ganit before. Nup is marriage, nuptial. So before marriage, you decided unsa inyong property regime. So nagsabat na mo, and then you got married. Whatever you have chosen, that is already forever. So dili pwede in the middle of the marriage. Marag dimdi ko ganahan atong nasabutan. So can we just change it? No, you cannot. So once you choose na, that will be forever. Hangtod mamatay mo, kung di magyay mo magbuwag, so hangtod mamatay mo. Kung unsa inyong gisabutan, the prenuptial agreement, that is already forever. You cannot amend that because the contract, no, the prenuptial agreement and the marriage contract itself is a special contract. It's not like any other contract which you can amend anytime you want. That is provided by the law. So kung unsay giingon sa law mo, nagyan na forever. Na siya. So be very careful. Do not rush into marriage like me. I'm already old para ako nagminyo. Ay, samok pa. Okay? Anyway, so muna siya. And then, so I hope clear sa atong minds, no? Unsay difference between partnership and conjugal partnership of gains. Okay. Partnership versus voluntary association. Partnership has juridical personality, again, except GPPs, while a voluntary association has no juridical personality. Partnership is organized for profit, and voluntary association is not always organized for profit. Like for example, let's say you want to create an association based on common hobbies. Now, let's say in your probinsya, you want to create a group of people sharing the same interests. For example, into biking, so you will create an association for that. So that's not always organized for profit. And then for partnership, capital is either borrowed or contributed, while voluntary association, here capital is not contributed, although fees are collected from members. Partnership, the partnership is primarily liable for the partnership debts. So unahon sa kuha ang partnership assets ang bayad sa partnership creditors, and then partners are only liable subsidiarily, meaning to say they will only become personally liable when the partnership itself cannot satisfy the debt. Okay, for voluntary association, the members are liable individually for debts which they authorized or ratified, because again, ang si voluntary association, wala mo good siya assets on its own. So, kung naa sila ganahan nga mga activities sa ilang association, then mga yun na po sila og contribution, di ba, from the members. And then partnership share in profits may be stipulated. Otherwise, if there is no stipulation, it will be shared in proportion to their contribution. While for voluntary association, if there are incidental profits earned, like for example, sa inyong association, let's say association of bikers, no? And then you decided among yourselves, mamaligya mo og mga t-shirts, printed t-shirts nga about biking, and also incidentally you will be earning profits, and then you will share the profits equally. But then again, ang main purpose sa inyong association is not really to generate profits, but rather, for example, to like enjoy a specific hobby, no, or share common interests. Okay. Give me 2 minutes ha, ako lang sang i-on ang aircon kay init na kayo. Okay, so let's proceed to the rights and obligations of the partnership. So right to contribution, right to warranty. Every partner is a debtor of the partnership for whatever he may have promised to contribute thereto. So we will relate this to what we have learned, that the existence of the partnership will commence upon meeting of the minds. It is not dependent upon the actual contribution, diba? Kung nagsabot mo nga, 100,000 ako i-contribute, ako at 20,000, ako at 30,000. Pagsabot pa lang daan ninyo, there's meeting of the minds, then the partnership is already created. Dili siya manginahanglan sa actual contribution. So if ever magani in the future, wala ka ni make good sa imong promise, no, mo contribute ka of this particular thing, you will become a debtor of the partnership. So meaning nakautang ka sa partnership sa whatever you may have promised to contribute thereto. Okay. With respect to contribution of money or property, a partner is obligated to contribute at the beginning of the partnership or at a stipulated time. If later time pa kamo promise nga, after 5 days, hatag ko sa ako ang 100,000. No, could be at the beginning of the partnership or at a stipulated time. The money, property, or industry which he undertook to contribute. So effect of failure to contribute, kung wala ka nakahatag sa imong gi-promise nga i-contribute, you will become an ipso iure debtor of the partnership. Kasi pasabot sa ipso iure, by operation of law. By operation of law, you become a debtor of the partnership. Nakautang ka sa partnership, even in the absence of a demand. The remedy is not rescission, but an action for specific performance with damages and interest. So therefore, for example, tulong mo ka partners, and then one of the partner promised to contribute 100,000. And then, wala dyan siya nihatag sa 100,000. So, unsa may remedy ninyo kamong duha nga nahabilin nga partners? Is it rescission? Sabot sa rescission is mo ipa-rescind na lang ang inyong partnership agreement, or action for specific performance. So, your right or your cause of action is for specific performance. So, i-ask si court to tell that partner nga wala pa ni contribute to perform his obligation. No, and this time with damages plus interest pagyud, no? Interest being the legal interest na 6%. So when the contribution is in goods, the amount thereof must be determined by proper appraisal of the value thereof at the time of contribution. So we have no problem kung money ang imuhang i-contribute kay naman si specific value ang money. But for property contribution, so you should appraise the value of the property contributed first, no? Kaya nga naman, for example, if wala mo nagsabot sa inyong share in profits, hinumdum mo nga, kani, if wala mo nag-decide sa inyong profit sharing, ang inyong pagbahin-bahin will be based in proportion to your contribution. Now, what if ang inyong contribute is property? How will you determine your percentage of sharing when in the first place, wa kakaibaw sa value sa inyong property? So, that's why if you are to contribute a property, you need to appraise the value thereof. I-appraise ninyo inyong butangan o amount. Kung pila ang value ani nga property nga ako ang gi-contribute. In case a specific and determinate thing is to be contributed, dapat na ay the partner contributing must warrant against its eviction in the same manner as a vendor. Remember your law on sales? Kaya naman sa inyong law on sales, you have this warranty against eviction. Unsay pasabutan ng warranty against eviction? Ang pasabutan na is, if ako, partner, ang akong i-promise nga i-contribute is my car, my Toyota Vios car with a plate number, blah, blah, blah. Mo na siya akong i-promise nga i-contribute. So that one is specific and determinate, right? Okay. There is a specific car I mentioned nga Toyota Vios with a plate number, ana. So when I contribute it to the partnership, I have an implied warranty against eviction in a sense that ang pasabot sa warranty against eviction is ako agad ni siya nga car, and then no one else will claim it from you. No one else will get it back. So ang pasabutan ng warranty against eviction is si partnership dili siya ma-evicted from the property. Walay laing tao nga muangkon ani. Okay, so that is warranty against eviction. Such that if in the future naadjay laing tao nga mukuha sa car kay siya di maguni kang Mary Ann, ako mag-good yung tinud-anay, so iyang gikuha, no? Hindi kuha. So naingon sa partnership, uy, gikuhaan ko og car. So kinsa man ang liable ana? Ako, si partner who contributed it. Why? Because I have an implied warranty against eviction. So I warrant that the partnership will not be evicted from that property that I have contributed. Okay, and then to deliver to the partnership the fruits of the property promised to be contributed from the time they should have been delivered without need of demand. So same with your law on sales. Now, for example, ako, partner ko, ang akong gi-promise is ang ako ang farmland. Ang akong gi-promise nga i-contribute is ang ako ang farmland. Unya, ayaw na lang farmland. Let's say, para simple sa akong mind. Let's say, ang atong partnership is magkuan tama piggery business. Okay, piggery business. Ang akong i-contribute, say, ang ako ang tulo ka pigs. No, nako tulo ka pigs. Mo ni ako i-contribute sa ako ato ang partnership. And I promise to deliver the pigs, let's say July 30, 2022. Now, pagka July 30, 2022, wala na ko gihatod ang akong tulo ka pigs. Wala ko gihatod. Pagka August, wag gyapon ako gihatod. Pero ang katong tulo ka pigs nako nanganak sila og 6 each. So, katong tulo ka pigs nanganak sila 6 ka buok piglets each. Now, come September, gipaninglan ako ninyo kay partners man ta sa atong piggery business. Gipaninglan ako ninyo nga, uy, asa naman to imong gi-promise nga i-contribute na tulo ka pigs. Ko, ay sorry, tara day akong gihatag ang tulo ka pigs nako. Sakto ba? No. I should deliver the 3 pigs promised plus the fruits. Unsay fruits niya ang iyang piglets. And we all know, di ba? Fruits could be natural, industrial, or civil fruits. So in that case, the young or the piglets of the pigs are considered natural fruits. So since I am already in default, no, sa pag-deliver nako sa pigs, the 3 ka pigs, what I should deliver is not only what I promised, but also I should also deliver the fruits of the property that I promised. Gets? Okay? So without need of demand. Okay, I have a question here. Attorney, in terms of contribution of property, why is it that the appraised value be followed and not the fair value of that specific property at that time? Okay. Appraised value could be anything. You could use fair value as your appraised value. Ang appraised value magod is general terms. Yeah? Ang kasabutan ng appraised value is the value that you have decided to assign to that property. So, of course, para dili mo maglalis pila ang appraised value, you can always choose the fair value of that specific property to become the appraised value. Okay, so again, dito dapat maglibog. Appraised value, wala na siya specific na value. Okay, appraised value is the term or muna siya ang pangan sa value nga imong gi-assign sa property. Muna siya ang appraised value. And how can you determine appraised value? You can use fair market value. Sa market man good for this same thing, ang baligya jud ani sa market is, let's say, 100,000. So, okay ra din yun na 100,000 atong appraised value ani mo. Yes. Okay, so that will become your appraised value. Okay. Next, in case a sum of money is to be contributed or in case he took any amount from the partnership offers. So, of course, if nag-promise ka og money, okay, nga money imong i-contribute, dapat muhatag ka at the time nga ni-promise ka nga ihatag nimo ang kwarta. Or else, if ni-default na pud ka, you will be treated as a debtor na nakautang ka sa partnership. So what if ni-default ka? So what you will contribute is not only the money that you have promised, but you also have to pay interest and damages from the time he should have complied his obligation or from the time he converted the amount to his own use respectively. So, kaning rules there is a letter C. This applies to two instances. Nawa man akong kamutay. 2 instances. So, first instance is when you promised to contribute money, but nag-default ka. Or second scenario is nanguha kag kwarta sa partnership coffers, gigamit nimo for your personal use. Okay? So if gigamit nimo for your own personal use, you are obliged to return the money plus interest and damages, right? And then you have the obligation to preserve the property with diligence of a good father of a family pending delivery to the partnership. So in my case, ganina, di ba, sa ato ang piggery business, ang akong promise is to contribute my 3 pigs So while wala pa nako siya gi-contribute, wala pa nako siya gi-turnover, no, wala pa nako gi-deliver siya sa partnership, I should take care of my 3 pigs. Dili pwede nga, dili na bitaw ni ako bitaw ning ihatag sa partnership. Wala sa mo ikaon ron ha. Dili lang sa mo limpyuhan, bahala na mo dira. Okay, no. You should preserve the property with diligence of a good father of a family. Remember the terms. Diligence of a good father of a family. Diligence of a father of a good family. So dapat good father of a family. Kaya unsa man ang good father of a family di ay responsible man na siya, di ba? So you should do that level of diligence, rather, of diligence. Okay, and then you have the obligation to indemnify for any interest and damages caused by the retention of the property or by delay in its obligation to contribute the sum of money. So, in all cases, if mo default ka sa imong gi-promise, whether money ba imong gi-promise or property ba imong gi-promise, as long as ni default ka, you are obligated to pay for interest and damages. Okay, so next, amount of contribution. So if you want to create a partnership, pila man dapat atong i-contribute. As a general rule, partners are to contribute equal shares to the capital of the partnership, except when there is agreement to the contrary, the contribution shall follow such agreement. So in essence, pwede rin gihapon mo magbuot, no? As a rule, dapat daw equal ang inyong contribution. But in reality, panagsar sa jud ni ma-follow nga equal jud tanan ang ihatag. So there will be partners who will contribute more than the other partners. So you can actually execute an agreement to the contrary. And then except also for industrial partners, because they will not contribute something na ay monetary value, diba? Di man siya mo contribute og money, dili sad siya mo contribute og property, but rather ang iyang i-contribute is ang iyang industry or iyang skill. Okay? So that's an exception for industrial partners unless he has also contributed capital pursuant to an agreement to that effect. So for example, ni contribute siya gamay, let's say ni contribute siya 5,000 and at the same time mo contribute siya sa iyang industry or skill. Okay, then additional capital contribution. So let's say ang atong partnership has already been existing for 3 years. And then later on, nagtawag po meeting, I think we need to, partners, we need to make an additional contribution. So when can we ask for an additional capital contribution from our partners? Unsa kani nga mga instances nga makapangayo ta og additional contribution? First, there is an imminent loss of the business of the partnership such that if dili ta mo add og additional nga contribution sa partnership, mamatay na yun ato ang partnership, no? So there is an imminent loss. The majority of the capitalist partners are of the opinion that an additional contribution to the common fund would save the business. So majority dapat na ay voting. So majority of the capitalist partners should agree nga there is really a need for us to add capital contributions. The capitalist partner refuses deliberately, not because of financial inability to contribute an additional share to the capital, and there is no agreement that even in case of imminent loss of the business, the partners are not obliged to contribute. So actually, you can prevent this from happening by including a provision in your partnership agreement nga in case of imminent loss, we are still not obliged to contribute. So if you are hesitant na nga, what if in the future, pangayuan na sad ko nila additional capital contribution. So paniguro na lang daan na sa inyong partnership agreement, gibutang na niyo dito nga. Bahalag na ay imminent loss to the business, we are not obliged to contribute. So any partner who refuses to contribute an additional share to the capital exempt an industrial partner. Ngano ganin exempt an industrial partner? Remember katong ato ang gi-discuss last time that an industrial partner will not share sa loss. Wala siya share sa loss, correct? So, of course, since wala man siya share sa loss, dili nimo siya pwede pangayuan og additional share because of an imminent loss of the business. So if you are not an industrial partner and you refuse to contribute an additional share to save your business or venture, you shall be obliged to sell your interest to other partners unless there is an agreement to the contrary. So as a general rule, if majority of the capitalist partners have agreed na kailangan ta mag-add o capital para ma-save na to atong business. But ikaw, yung ka nga, dili ko willing mo hatag og additional contribution. Bahala mo diha. So, unsa man ang effect? You shall be obliged to sell your interest to other partners. You will then cease to become a partner. Ang imuhang share paliton sa imong uban nga partners. So, since mawa naman imong share, you cease to become a partner. Okay? So, muna siya ang repercussion if dili ka mo contribute og additional capital. Okay, contribution of industry, we have no problem with this because if ang imuhang contribution as a partner is not money, property, but rather industry, you are obligated to contribute your industry at the stipulated time. So if based sa inyong partnership agreement, magsugod ka o exert sa imong efforts no in January 1, 2023, then on that stipulated time, kailangan na jud ka mo trabaho. Okay. Next, ang partnership itself has the right to have sums applied per rate. So as a general rule, pasan din ako no kay page 9 page 9. So as a general rule, a partner authorized to manage the partnership who collects a demandable sum owed to him in his own name from a person who also owes the partnership a demandable sum is obliged to apply the sum collected to both credits per rata, even if he issued a receipt for his own credit only. Which pasabot ani oy. Sabot ani tayo. Example, managing partner ka. Si kamutan, wala mo nag-assign og managing partner. Kamutanan, you can act to. So, you are a partner. And then, let's say, si Mr. A, a third person, no? Si Mr. A, nay utang, ako na lang, partner ko. Si Mr. A, nay utang na ko. At the same time, si Mr. A, naasad siya utang sa partnership. So, murag na murag conflict, no? Conflict of interest. Nibayad, okay, let's say, si Mr. A, na siya utang na ko 10,000. Naasad siya utang ni partnership jud mismo 10,000. Karon, si Mr. A, nibayad siya, nihatag siya na kong kwarta, 10,000. Okay, so nahimo kong acknowledgement receipt na, okay, acknowledging receipt of 10,000 from Mr. A in payment of his personal debt to me. Ang say giingon sa law, sa partnership law, ingon dito, nga since si Mr. A, naa siya utang nako as partner, nasa siya utang sa partnership, inig-collect daw nako akong partner, naka-collect ko kwarta from that person. Ako siyang i-apply pro rata sa utang niya nako and utang niya sa partnership. Even though daw sa ako ang acknowledgement receipt, akong gi-mention dito nga ang 10,000 nga akong na-collect from Mr. A is para rana sa iyang utang nako while labot sa partnership. Nagets ninyo? So kay ang 10,000 man ang ibayad ni Mr. A, magtunga di ay ni sa partnership. Kaya naman siya utang ni partnership nga 10,000, naasad siya utang ako nga 10,000. So 10 plus 10, 20. So ang share nako is 10/20. Ang share sa ni partnership is 10/20.
So sa 10,000 nga akong na-collect ni Mr. A, 5,000 will go to me and the other 5,000 will be applied sa iyang utang sa partnership. Okay? Gets? So despite nga ang ako ang gi-issue niya nga resibo, akong gi-specify nga ang katong 10,000 is bayad ra to niya sa iyang utang na wa tay labot sa partnership. Okay? The partnership law specifies nga dapat pro rata jud. Okay, pro rata. Kay para dili ma-prejudice ang partnership, no? Pro rata. So the requisites for this particular provision to apply is that first, there exist at least two debts. One where the collecting partner is the creditor and the other where the partnership is the creditor. Then both debts are already due and demandable. And the partner who collects is authorized to manage and actually manages the partnership. Okay. Exception sa pro rata nga rule. If the receipt was issued for the account of the partnership only, the sum shall be applied to the partnership alone. So lahi, if for example, if bali ang scenario, ang resibo sa 10,000, gibutang dito nga this is in payment for Mr. A's utang sa partnership. Pwede ba kumaingon nga, uy, tagay sa kog 5,000, uy, pro rata good, dili. Okay, so if the resibo is only for the partnership alone, it will remain with the partnership. Dili ko maka-appeal sa pro rata. But if ang resibo is gibutang na ko under my own name nga ang iyang gibayad is ang sa iyang utang nako, then na I share si partnership ana because mag-pro rata mi. Okay? But kung other way around, 100% goes to the partnership. Then, another exception, when the debtor declares at the time of making the payment to which debt the sum must be applied, and if the personal credit of the partner is more onerous to him, it shall be so applied. So if si Mr. A, pagbayad niya sa 10,000, iya dyan gi-specify nga, kaning 10,000 nga akong gibayad ha is para dyan ni sa akong utang nimo, partner, ako partner ko. Ayaw na apila ang sa partnership, imuha ra gid na. And then ang iyahang utang nako is more onerous. Unsay pasabot sa more onerous? Mas sakit sa heart. Pasabot anang more onerous. Mas sakit sa heart. Unsay pasabot sa mas sakit sa heart? For example, ang iyahang utang nako is interest bearing 10%. Ang iyang utang sa partnership is interest bearing 2%. So asa may masakit sa iyang part, di ba? Ang 10%, so iyang utang nako is more onerous to him. So this is an exception to the pro rata rule. In this case, the 10,000, since gi-declare magyud ni Mr. A nga ang kaning 10,000 ako ning pangbayad sa akong utang nimo, and because your utang is more onerous, the whole 100,000, the whole 10,000 will be applied to my credit to you lang. Why labot si partnership? Okay, so I hope that's clear. And then the partnership has a right to be compensated. Every partner is responsible to the partnership for damages suffered by it for its fault, and he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. So, ang pasabot ani is, if ikaw, partner ka, and because of your negligent acts, you caused damage to the partnership, kailangan ni mo bayaran the partnership has a right to be compensated. So si partnership mismo, na siya right nga, mangayo og damages from you. Okay. So set off of liabilities as a general rule, the liability for damages cannot be set off or compensated by profits or benefits which the partner may have earned for the partnership by his industry. Sabot ani kay, okay, mo yan ka, o sige, I acknowledge nasayop ko, and then na ako'y obligation to pay damages to the partnership. But pwede ang gamiton lang nga pangbayad na sa damages is ang akong share sa profits, kay since anyway Namo ko share sa profits. So, ang kato na lang akong share sa profits, akong ibayad sa damages. Can you do that? Answer, no. As a general rule, you cannot offset it from your share. Why? Because, so ang rationale sa kaninga rule is that the partner has the obligation to secure the benefits of the partnership. As such, the requirement for compensation that the partner be both a creditor and a debtor of the partnership at the same time is not complied with. So, ang katugaling sa extinguishment of obligations ninyo, I remember mo sa katong palareconcom, no? Palareconcom, no? Com is compensation, no? Sabot sa compensation is set off. So, di ba naman specific requirements for it to be applicable. So, in this case, it is not applicable, no? Ang set off or ang compensation sa inyong palareconcom, no? Is not applicable in this case. So, therefore, you cannot set off. Exception, when you have a case in court for this purpose, gikiha ka sa partnership, the court may equitably lessen the liability if, through his extraordinary efforts in other activities of the partnership, unusual profits were realized. So, as an exception to the rule against set off, no, as a rule, dili nimo pwede i-offset. Offset, parehar na sila, no? So, dili nimo pwede i-offset ang imuhang bayronon nga damages sa imuhang share sa income. Exception daw if because kuno exert ka extraordinary efforts, and because of your extraordinary efforts, the partnership was able to earn unusual profits. For example, no, ang inyong partnership is nag-earn siya og 50,000 per month. Because you exerted extraordinary efforts, the partnership was able to earn 150,000 for that month. So, with respect to the unusual profits, pwede di-ay mo siya magamit as a deduction sa imuhang damages payable to the partnership. However, there is still no compensation or set off in this case because ang set off man is imo yung ibangga tanan, no? Ang duha ka amounts imong ibangga. But here just says the court may equitably lessen. Pwede niya pagamyan, but dili necessarily na iya na yung i-offset. Okay? So the rule remains that there will be no set off. It's just that because of your extraordinary efforts, there is unusual profits, then the court may equitably lessen. Right to accounting of profits received without the consent of the other partners. So again, every partner must account to the partnership for any benefits and hold as trustee for it any profits derived by him without the consent of the other partners from any transaction connected with the formation, conduct, or liquidation of the partnership or from any use by him of its property. So, for example, the partnership has a car, no? Ang title over the car is in the name of the partnership. And then, one of the partners used the car for personal, and then nag-grab driver day siya kada gabi. So, nag-grab driver siya kada gabi, wa siya na ng his other partners. Nagigamit niya ang partnership car para mag-grab every night. So, ang katong profits nga iyang na-receive, now because this was without the consent of the other partners, he has to pull them and then contribute them to the funds of the partnership. Okay, mura siya og mo na imuhang consequence for not getting the consent of the partners first. Then, obligation to reimburse partners. The partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership and for the corresponding interest from the time the expenses are made. It shall also answer to each partner for the obligations he may have contracted in good faith in the interest of the business and for the risks in consequence of its management. Ang pasabot lang jud ani kay di ba we should always remember that the partnership has a separate juridical personality apart from its partner such that, for example, if one of the partners inigamit sa siya sa iyang own money, let's say si partnership, kailangan siya og bag-ong ink sa printer. So kay na naman gyud, let's say ako partner ko, let's say na naman gyud ko sa mall, so nigamit sa ako ang own kwarta to buy the ink. So I have the right to be reimbursed because this expense is for the partnership and dili siya personal na ako. But because my personal money was used, dapat ilisan ko sa partnership. Mora na ang pasabot ana. Okay? Rights and obligations of partners intersect. So ang pasabot aning partners intersect is among each other. No, kamo sa inyong other partners. Right to associate another in share. Every partner may associate another person with him in his share. The admission of the associate to the partnership, however, requires consent of all the other partners, even if the partner having an associate is a managing partner. I think we have also discussed this last time. For example, ang ako ang share, akong i-assign to someone else. Kaya lagi, for example, ako nakautang ko sa isa ka particular person. And then akong gi-collateral, ang ako ang share niya. So siya na kumbaga ang holder sa akong share. Can I do that? Yes, I have the right to associate another in my own share. But the assignee, the person that ako ang gihatagan or gitransferan sa ako ang share, will not become a partner of the partnership. Because to do that, we have to get the consent of all other partners. But the fact remains that I can still transfer my share to another or associate my share to another even without the consent of the other partners. Ang consent lang is only needed if I want that other person to become a partner. Okay, but kung iguranin mo siya assignan sa imong share without the intention of him being a partner, then you can do that. You have the right to associate another in your partnership share. The arrangement refers to a contract of sub-partnership, which is a partnership within a partnership, distinct and separate from the main partnership. It is considered a modification of the original contract. Actually, do not confuse yourself with this. This is just an opinion of De Leon. The fact remains that with respect to your current partnership, that other person will not become a partner. So kung akong gi-associate another sa ako ang share, I am still the partner. Katong other person, dili siya partner. He will only become a partner once the other partners will consent to his admission. Okay. And then a partner has a right to inspect partnership books. Partnership books shall be kept at a place agreed upon with the partners where there is no such agreement. Kung wala mo i-agreehan nga place, kung asa ibutang ang inyong books, adto na siya general rule, adto na siya sa principal place of business of the ship. And then every partner shall at any reasonable hour have access to and may inspect and copy any of them. So of course, take note at any reasonable hour. So for example, you agreed that the partnership books will be kept inside the home of your managing partner. Can you do that? Yes, because you can do it at you have the right to agree. The partnership books shall be kept at the place agreed upon by you. Let's say the place agreed upon is the house or home of your managing partner. Yeah, let's say no alas 12 gabi wa pa ka nakatug, bisag unsa na lang imong gi-overthink. Kapantay mo na sa middle of the night. So kung saan lang hunahunaan, what if kahunahuna ka nga? Dugay naman di ko wala nakakita sa partnership books. Unsa na kay mga na-record dito nga mga transactions. And then i-adto ka sa balay sa inyong managing partner na nuktok ka dito. Excuse me, pwede na ko tan-awon ang partnership books? Under article blah 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 of the civil code, I have the right to inspect partnership books. Yung mga imong partnership managing partner na po ang nakajay, no? You shall have the right to inspect, but provided that you do it at any reasonable hour. So what is reasonable hour? No? Any reasonable hour means reasonable hours on business days throughout the year. This has been clarified by the Supreme Court in the case of Pardo versus Lumber Company. So dili pwede anytime nga imong ganahan at your convenience. No. Dapat you follow reasonable hours on business days. Like for example, 8 a.m. to 5 p.m. or could be extended to until 6 p.m. I think that is still reasonable. No? Then you have the right to ask for a formal account. So as a general rule, the right to a formal account of partnership affairs accrues only when the partnership is dissolved. So, ani ding number 3 nga right nimo as a partner, as a rule, this can only be demanded upon partnership dissolution. So, unsa tay pasabot aning right to ask for a formal account? Ang pasabot ana is more bag full accounting ba nga? Ang partnership assets were sold at a price of this much. So, mo na ni ang total proceeds. And then, from the total proceeds, gikuha na mo og this much to pay off the partnership creditors. Mo na lang ning habilin for sharing. Okay? So, as a rule, this right accrues only when the partnership is dissolved. Exceptions in the special and unusual cases mentioned in Article 1809 of the Civil Code, formal accounting may be demanded by any partner even before dissolution in the following cases. First, if he is wrongfully excluded from the partnership business or possession of its property by his co-partners. Partner ko, pero if mo adto ko sa office, di ko nila pasudlon. Wala ko kaybaw, unsain hitabo na sa partnership. Wala ko kakita sa financials and all. So I have the right to ask for a formal accounting even though wala gyud na dissolve ang partnership. Okay? I think kani nga mga instances magod is more siya og common sense lang sad ba. The next, if the right exists under the terms of any agreement, so if based on your partnership agreement, there is a specific provision there that each partner has a right to ask for a formal accounting even before dissolution. So you can do that. Then if without his consent, a partner has derived profits from any transaction connected with the formation, conduct, or liquidation of the partnership or from any use of partnership property, you should relate this to here, kaning right to accounting of profits received without the consent of the other partners. Now you can have the right to ask for a formal accounting. And then whenever other circumstances render it just unreasonable, so this is like a catch-all provision. I say catch-all provision because this will catch all other possible circumstances that would really look like or seem like it is really reasonable for you to ask for a formal accounting. So as long as the partnership exists, any of the partners may demand an accounting of the partnership business. Prescription of said right starts to run only upon the dissolution of the partnership when the final accounting is done. Okay. Then property rights of partners. In general, the property rights of a partner are the following: rights in specific partnership property, interest in the partnership, and right to participate in the management. Okay, so I think this is also understandable, Raman said. Okay, so here, let's distinguish partnership capital from partnership property. Okay, partnership capital has a constant value because again, in your financial accounting, diba, you have experience computing the partnership capital. This is with constant value. The partnership property's value varies actually with market conditions. Partnership capital includes only actually contributed and promised capital, while partnership property includes the contributions plus the property acquired by the partnership itself. This is very, very clear sa minds sa accounting students. This distinction could be more challenging for those na walay background sa accounting, but for us, we have a good foundation of accounting, so I think this is clear naman. Ownership of certain properties. The ownership of property used by the partnership depends on the intention of the parties, which may be drawn from an express agreement or their conduct. So for example, I have a car and then my intention is not really to contribute or transfer the title of the car, but it's just that I would contribute the use of such car. Can I do it? Can I do that? Yes, I can contribute the use of the car, but not the title of the car itself. So this the ownership of such property will be drawn from our agreement. A partner may allow the property to be used by the partnership without transfer of ownership. Mo siya ang gingon, contributing only the use or enjoyment thereof. He may also hold title to partnership property without acquiring ownership thereof. So vice versa. You become a trustee. Now, in this case, you will become a trustee of the partnership property. So the beneficial owner will be the partnership. So kabantay mo kanina mga terms, you have learned this in your sales and agency nga law subject. Property acquired by a partner with partnership funds is presumed to be partnership property. So of course, if ang gigamit nga kwarta sa pagpalit sa isa ka property kay ang partnership funds, so ang katong gipalit nga property is presumed to be partnership property. Lain sad kayo, no? The same presumption also arises when the property is indicated in the partnership books as a partnership asset. So kung based sa libro sa partnership, ang kani nga property gilista no as one of the partnership assets, then there is a presumption that the title over such property is with the partnership. And then there are other factors that may be considered to determine ownership of the property. So you have to look at the totality of the circumstances no, that will help you determine kung kinsa jud ang owner sa property. Ikaw ba as partner or si partnership? Okay, rights in specific property. The partners have equal rights to possess partnership property, but take note for partnership purposes. Okay, so so kamutanan partners na may right to use the partnership assets as long as the use is for official purpose, no partnership purposes. For other purposes, the consent of his partners is necessary. So like for example, if you want to use your partnership car, no nga mag-grab driver ka kada gabi, so you need the consent of your other partners. Otherwise, ang sagay ito'y kuan. So otherwise, you may be asked to do formal accounting, or you can be excluded po di ay, no? You can be excluded from the partnership. A partner's right in such property is not assignable except when all the partners assign their rights in the same property. So, for example, tulo ta kabuk partners and then naay usa ka partnership car. So, of course, kitang tulo kabuk partners, we have a right over such property. Now, pwede ba na ko i-transfer ang right to use the partnership car to another person? Answer kay no. Except when all partners, katong tulo ka partners, assign their rights in the same property. The right is not subject to attachment or execution except on claim against the partnership. So, my right to use partnership assets cannot be used by my creditors in their case against me for collection of sum of money. That is excluded. In case of such attachment, kani except daw if is a claim against the partnership, except pasabot, except if the creditor asking for the attachment or execution is actually a creditor of the partnership itself. So in case of such attachment, the partners or any of them or the representatives of a deceased partner cannot claim any right under the homestead or exemption law. So this exemption, no, kanina the right is not subject to. So this only applies for creditors nga personal to the partners. If the creditor is a creditor of the partnership, then this exemption is not applicable. The right is not subject to legal support. Like for example, giabandon mo imong anak. Can your anak ask that your right over the partnership assets be used as payment for his support? Answer no. It is not subject to legal support. And it contemplates tangible property. So for those intangible property, dili na siya applicable. Interest in partnership, a partner's interest in the partnership is his share of the profits and surplus. Of course, if you own 50% of the partnership, then your interest in partnership is that 50%. Okay, assignment of interest. Assignment by a partner of his whole interest in the partnership of itself, again, does not dissolve the partnership. Like I have exemplified a while ago, no nga, if I assign my share to someone else, I will still remain as the partner. So it will not dissolve the partnership, or does not entitle the assignee to interfere in the management or administration of the partnership business or affairs. It does not entitle the assignee to require information or account of partnership, it does not entitle the assignee to inspect the partnership books. Why? Because kani siyang 1, 2, 3, these are rights of a partner. And again, si assignee is not a partner. He will only become a partner once the other partners consent. Okay? So unsa raman di ay rights ni assignee? It merely entitles the assignee to receive the profits to which the assigning partner was entitled. So ako man ang nag-assign sa akong share dito sa lain person. Ang katong lain nga person, katong si assignee nako, ang only right niya is to get my share of the profits. And in case of fraud in management, avail himself of the usual remedies provided by law, such as dissolution. So another person can ask for the dissolution of the partnership. And in case of dissolution, receive his assigner's interest and require an accounting from the date only of the last account agreed to by all partners. So the reason for this is that it would effectively allow a third party to participate in the affairs of the partnership, and would basically have a stranger become a partner without the consent of all partners, right? So this is the reason why he is prohibited from doing these things. Okay. Okay pa mo? Okay, risk of loss of things contributed. Okay, so for if the thing contributed is specific and determinate thing which are not fungible, only the usufruct is contributed. The risk of loss is borne by the partner because he remains the owner of the things. So only the usufruct, kung sige ni usufruct, that is use or enjoyment. Mo na ang usufruct, ha? So because full ownership is fun, F-U-N. So full ownership is equal to usufruct plus, sige ning N, nawa na siya sa akong mind. Baliki ko ana. Bis na anong to sa akong utok. Basta full ownership is equal to usufruct plus naked title. Naked title. Naked title. So full ownership is equal to usufruct plus naked title. That means that if ang imuhang gi-contribute is only the usufruct, napinabilin nga N, di ba? And the naked title still belongs to you. So since the naked title belongs to you as the title holder, you will be the one to bear the risk of loss. Okay? And then if what is contributed is specific and determinate things, the ownership of which is transferred to the partnership, then since the partnership naman there is transfer of ownership naman, so the partnership will be the one to bear the risk of loss. Kaya siya naman ang owner. Fungible things. The risk of loss of things contributed which are fungible things belongs to the partnership because use is impossible without the things being consumed or impaired. So ganun yung mga fungible things. Like for example, grains of rice, sugar, things that are determinable siya when they are weighed or measured. Mo na ang mga fungible things. Things contributed to be sold. The risk of loss belongs to the partnership, for there cannot be any doubt that the partnership was intended to be the owner. For things brought and appraised in the inventory, the risk of loss belongs to the partnership because of the intention of the parties was to contribute to the partnership the price. This is price. A price of the things contributed with an appraisal in the inventory. Thus, there is thus an implied sale. So, So always remember that ownership carries with it the the obligation to bear the risk of loss. So whoever is the owner will bear the risk of loss. So here the list presupposes delivery because without delivery the loss is borne by the partner. So kani nga mga rules there, this is only applicable when you have actually delivered the thing that you have promised to contribute. Next, as a partner, you have the right to participate in the management. Management of the partnership is primarily governed by the agreement of the parties in the Articles of Partnership. It may be stipulated that the partnership will be managed by all partners or a number of partners appointed as managers, which may be appointed in the Articles of Partnership or after constitution of the partnership. So again, if there is no stipulation, all of you can manage, but you can also appoint a specific person as the manager. Asa man mo siya pwede i-appoint? Pwede in the Articles of Partnership or pwede later on in a separate agreement. Dili necessarily sa Articles of Partnership. So if you are a managing partner, so what are your powers na? As a general rule, the partner designated as manager in the articles may execute all acts of administration despite opposition by the other partner. Since you have been appointed as a managing partner, that means at the onset, the other partners trust you, no, with the operation of the business. So you have the power to execute all acts. So unsa ni nga acts? Acts of administration, ha? Walay labot dira acts of ownership. You have to remember the distinction between acts of administration and acts of ownership. So kani nga rule dire nga si managing part can execute all acts despite opposition. This pertains to acts of administration. Unsa day na kung ipa-clear na to sa tong mind, unsa day ng acts of administration? Pasabot sa acts of administration are those acts that are necessary in the ordinary course of business. Okay? So, for example, if mayon si managing partner, ganahan ko nga ibaligya na na atong partnership. Okay, baligya ni nako ni Mr. A. Bahalag di mo musugot, no? Despite opposition. Kaya ingon si law on partnership nga I can execute acts despite of your opposition. Is the managing partner correct? Answer kay no, because in this case, his act is not anymore in the ordinary course of business, right? So it's not anymore an act of administration, but rather it is an act of strict ownership, which is not covered in this rule, correct? So, unsa man ang examples acts of administration? Choosing your supplier. For example, ganahan ko ni supplier A. Unya ningon ang uban nga partners nga, ayaw lang na si supplier A, pwede si supplier C na lang. Pwede ba i-insist ni managing partner nga si supplier A jud? Yes. Because the act of choosing a supplier is covered under the acts of administration. Okay? Ordinary course of business man siya. However, he cannot do so when he acts in bad faith. So dapat in good faith tanan iyahang kuan. Pero kung in bad faith gani like gituyo jud niya nga si supplier A iyahang pilion mas mahal kaayo as compared to the normal market price. So that is already in bad faith. He can the managing partner cannot do that. Okay? So what if wala na mo nalipay sa attitude ni managing partner ninyo? What can you do? So you can revoke actually. But however, as a general rule, the power is irrevocable without just or lawful cause. So meaning to say, power is irrevocable, but if you have a justification or a lawful cause for the revocation of the power of the managing partner, then you can revoke his or her power. But for example, ang inyo yung reason kay too personal, like for example, tulo mo girlfriends, naghimo mo partnership, and then one partner was appointed as the managing partner, and then galagot mo kay siya ang giminyuan sa inyong crush. I-revoke na mo iyahang power as managing partner, galagot mi niya. Is that allowed? Answer, no, because power is essentially irrevocable. It may only be revoked if you have a justification or a lawful cause. Okay, so the powers of the managing partner may be revoked if appointed in the. So how are we able to revoke this? If the power of the managing partner, or the appointment rather, if the appointment of the managing partner was made in the articles of partnership, you can revoke the power when there is just or lawful cause for revocation, and the partners representing the controlling interest revoke such power. Okay? So, kailangan niya mag-vote sa mga partners. If appointed after the constitution of the partnership, kung ang iyang appointment daw as a managing partner was not made in the articles but rather in any other contract, you can revoke the managing partner's power anytime and for any cause. So, ang katudaing rule on just and lawful cause, that is only applicable in cases where the appointment of the managing partner is made through the articles of partnership. If it was made in any other document other than the articles, then you can revoke it at any time for any cause. You do not need a just and lawful cause for the revocation of his power. Why? Because such appointment is a mere delegation of power, and it is not founded on a change of will on the part of the partners, the appointment not being a condition of the contract. It is merely a simple contract of agency which may be revoked at any time. Removal, however, should be done by the parties having the controlling interest. So, so you still have to get the vote of the controlling interest partners. Okay, but this time you do not need lawful or just cause. Can you appoint more than one managing partner? Yes, you can do so. When there are two or more managing partners appointed without specification of their duties or without a stipulation on how each one will act, each one may separately execute all acts of administration, and if any of them opposes the acts of the others, the decision of the majority prevails. Sabot sa majority diri is majority of the appointed managing partners. In case of a tie, the partners owning the controlling interest will decide. Okay? So, for example, if you have two managing partners, each one of them may act separately. But if wala sila nagkasinabot sa isa ka butang, no? The decision of the majority prevails, but wala may majority sa duha, usa-usa man sila. So, in case of a tie, the partners rather owning the controlling interest will decide. So this is applicable, these rules are applicable if there are two or more partners who were appointed as managers and there is no specification of their respective duties. Because if there is a specification of their respective duties, then their duty is, their power to act is limited by those duties that have been specified. So they could not encroach in each other's respective duties. Then there is no stipulation that one of them shall not act without the consent of all other partners. Okay, so kaning kuan dire na each one may separately execute all acts of administration. This is applicable if there is no stipulation nga kailangan na ay consent sa tanang managing partners every time na ay buhaton ang isa ka managing partner. The right to oppose is not given to non-managers because in appointing their other partners as managers, they have stripped themselves of all participation in the administration. Therefore, if you have a managing partner, no, and then of course the managing partners mo siya og naay authority to make decisions. And then if you are not a managing partner, you have no right to oppose whatever is decided by the managing partner. The other managers, however, should make the opposition before the acts produce legal effects insofar as third persons are concerned. So, in essence, who can oppose? Ang maka-oppose lang is other managing partners. Okay? So, ano din to, if ni-oppose sila, so for example, itulo ka managing partners, and then one managing partner wants to do something, and then the other two opposes, then majority wins, correct? Okay. So if there is an irreconcilable deadlock, those who vote against the contract shall prevail, the same having been entered into without authority. So ang pasabot sa irreconcilable, for a while. Okay, so if there is an irreconcilable deadlock, those who vote against the contract shall prevail. So therefore, the proposed contract will not push through. Stipulation of unanimity. In case there is a stipulation that none of the managing partners shall act without the consent of others. So, di ba, dere, atong gidiscuss before, if there is no provision na dapat mo act ang managing partners with consent sa other managing partners. But this time, there is a stipulation of unanimity. Here are the applicable rules. The concurrence of all is necessary. Ang pasabot ani of all managing partners. Sorry ha, naisig agi-agi. Nako. So the concurrence of all managing partners is necessary for the validity of the acts, and the absence or disability of one cannot be alleged unless there is imminent danger or of grave or irreparable injury to the partnership. Sa pasabot. So for example, if tulo ka buok managing partners and then there is a stipulation of unanimity, meaning inyong stipulate dito nga kaning tulo ka managing partners dapat mo agree gid sila sa tanan nila maa sila jud tulo mo agree. Unanimous vote jud. And dili nila pwede mo-allege ang absence or disability. For example, ay absent man si managing partner number 1. Pwede kami lang magsabot ni managing partner 2 o 3. So dili siya pwede. You cannot allege that. So you really have to get the unanimous vote unless there is imminent danger of grave or irreparable injury to the partnership. Okay, so when there is no agreement as to the manner of management, the following rules shall apply. So for example, if you did not appoint any managing partner, all partners will be considered agents. So maning mutual agency. Manoy pasabot sa mutual agency. Whatever anyone does alone binds the partnership unless there is a timely opposition to the act. Any important alteration in the immovable property of the partnership, even if useful to the partnership, requires unanimity. Okay, ngano man ni unsa man ka ang personality ani, because if maghisgot na gutag alteration sa immovable, sa pasabot sa immovable real properties. If alteration naman good sa immovable property, dili na ni siya act of administration, but rather act of strict ownership, which requires unanimity. If the alteration is necessary for the preservation, however, consent of the others is not required. Okay, so kung preservation ang purpose of the property, that is considered as an act of administration. So you do not need the consent of the others. If one partner refuses, but that refusal is manifestly prejudicial to the partnership, court intervention may be sought. So for example, in this case, di ba, kailangan unanimous vote, but then let's say out of 10 partners, only one refused to give his vote. So kailangan man unanimous, dili jud ma-push through kanay usa nga wala ni hatag sa iyang consent. So if the refusal is prejudicial to the partnership, then you may ask the courts to authorize this contract for the partnership. The consent need not be expressed, pwede implied. Unsa nang implied? Like for example, wala ra kay comment, so that is implied consent. It may be presumed from the fact of knowledge of the alteration without interposing any objection. Okay, sige. Consequences of mutual agency. So, once again, ng mutual agency, all partners can act, and their acts will bind the other partners and the partnership itself. So, there is effectively a mutual agency in the following cases. Partners can dispose of partnership property even when in partnership name. An admission or representation made by any partner concerning partnership affairs is evidence against the partnership. Notice to any partner of any matter relating to the partnership affairs is noticed to the partnership. So kung ang i-inform lang is isa ka partner, that means all partners there are deemed to be informed, said, or notified. Wrongful act or omission of any partner acting for partnership affairs makes the partnership liable because all your acts will bind by the partnership. And the partnership is bound to make good losses for wrongful acts or misapplications of partners. Right to be reimbursed by the partnership. I think I have already covered this a while ago, so you can read this on your own. Right to ask for dissolution. Okay, because again, a partnership is personal in nature. So if you do not want to become a partner now, or you want to dissolve your partnership, you can do so. Right to ask for, you have the right to ask for dissolution. And then you have the obligation to render true and full information affecting the partnership to any partner. So you need to disclose important information to your other partners. Or if you have a deceased partner, you have the obligation to disclose important information to the legal representative of that deceased partner. Or wala namatay but incompetent siya, you also have the right, or I mean the obligation to disclose it to the legal representative of that partner. Even without demand, honesty demands the giving of vital information and refraining from all kinds of concealment. After all, you being a partner, that means you should think of the welfare of the partnership. So if you will not disclose any vital information, that will be prejudicial to your partnership, and ultimately it will affect you because you have a share in the partnership. So by information, kaning vital information, it is meant that which can be used for partnership purposes. It is in the sense of a property which the partnership has a valuable right. So not any kinds of information lang hang. Tanan na lang yung information, makimarites ra ka. So only those information that can be used for partnership purposes. So dili ka pwede pugson nga mo disclose o any information nga dili related sa partnership. Okay? So, let me get my charger first. Okay, and then you have the obligation to account and act as trustee. So if you actually, sabtan regulation, no? Like for example, if you receive something and this something should be for the partnership, you holding it will be treated as like you are the trustee. Ano? You hold it in trust for the partnership. You should not use it for your own benefit. Okay? So every partner must account to the partnership for any benefit and hold as trustee for it any profits derived by him without the consent of the other partners. Like akong giingon kanina no nga. Katong gigamit nimo ang car as ay Grab driver ka, no? Gigamit nimo ang car ni partnership. So all profits that you derive from it will be inured to the benefit of the partnership. So you hold it as a trustee. Okay. Okay, I think clear na siya sa taman, so we can skip this and then we focus on the other concepts nga wala pa nato nagian. Okay, I have for a while. So here, I think we have also discussed this in a sense nga, katong mga industrial partners, diba, they are prohibited from entering into another business even if dili siya direct competition sa partnership. But for capitalist partner, ang prohibition is lesser in scope in a sense nga ang capitalist partner is only prohibited from engaging in another business that is in direct competition sa ato ang current nga partnership. Okay. So the test here is the possibility of unfair competition. Okay, so as partners, we have the obligation to share in the profits or losses. I think we also have discussed this before, diba nga? For capitalist partners, you have the right to share in the losses. However, industrial partners are exempted. No, they have no obligation to to get a share of the losses. But ato akong gi-emphasize last time na with respect to third persons, liable gihapon si industrial partner. It's just that after niya mo bayad to third persons, na siya right to ask for a reimbursement from the other partners because again, industrial partners are exempted from sharing sa losses. And then I also discussed this before, no nga, you cannot include a stipulation in your agreement, no. One of the partners will be excluded from a share in the profit or a share in the loss. Okay. So, okay, so those are your rights and obligations of partners inter se, so meaning among themselves. This time, obligations of the partnership or partners to third persons. You have the right to operate under a firm name, of course, because the partnership has a separate juridical personality, and you have a right to use a firm name. Okay, so for the firm name, the partners may adopt any firm name desired. Exceptions: they cannot use a name which is identical or deceptively or confusingly similar to an existing or corporation or partnership or to any other name already protected by law or is patently deceptive. So, diba, your partnership should be registered in the SEC, no? For particular instances, like for example, if you have a capital of at least 3,000 or if there is an immovable property that is contributed, so you need to register your partnership in the SEC. So pag register pa lang daan ninyo sa SEC, magpa-reserve manggod mo og name. And then the employees or the officers of the SEC will investigate whether there is already an existing corporation or partnership that has that name. If wala, then you may be granted that name. Then use of names of deceased partner in law firms is permissible provided that the firm indicates in all its communications that said partner is deceased. Okay, and then you have liability for partnership debts. So again, kinsay primarily liable for partnership debts, it is the partnership itself. And then the partners themselves will only be subsidiarily liable. So their liability is subsidiary. Unsay pasabot sa subsidiary? Kaduha na lang. So meaning unahon sa to ang sa partnership assets gamiton para isatisfy ang liability sa partnership. If kuwang, that's the time that you run against the partners personal assets. So their liability is subsidiary. The liability of the partnership itself is primary. Okay. And then, so if in case kuwang ang partnership assets to satisfy the liability of the partnership, So, di ba, modaga na mo sa personal assets ni partners kaysa subsidiarily liable lagi sila. So, pila man ang i-contribute, pila man ang liability sa each partner. So, their liability is pro rata. So, the basis for prorating, okay, this is based on the number of partners and not on the amount of their contributions to the common fund subject to adjustment among the partners. So, magtunga-tunga mo, dito no ihatag ninyo sa third person, and then among yourselves, pwede na mo mga reimbursement from each other. Depende sa inyong sabot. So again, the industrial partner is not liable for losses, but he is not exempt from this liability. Ano ganito? Kay lagi, si industrial partner, when it comes to third persons, kailangan gihapon siya mobayad. But mangayo lang siya og reimbursement from the other partners. Okay. Stipulation against individual liability. So for example, nagsabot-sabot mo among each other nga, ako ha, exempt ko from third person liability. Okay? Pwede ba na? Yes, pwede na siya, but that is only valid among yourselves. It will not be valid against third persons. So therefore, even if nagsabot na mo nga, wa jud kay labot ha sa share sa liability, the third person can still collect from you. It's just that you can ask reimbursement from the other partners. Okay. So, may saba-saba. Okay. What else? Liability of partners for partnership contracts. Okay. So, usual business. So, muna yung ordinary course of business. Any act of a partner which is apparently for the carrying on of the usual business of the partnership binds the latter. Latter being the partnership, including the execution of any instrument in the partnership. Exception, the partnership is not bound when the following concur. The partner has in fact no authority to act, and the person with whom he deals has knowledge of such fact. So for example, you have a managing partner. So katong mga non-managers, they cannot enter into transaction with other person. But he still, despite that, he still tried to enter into a contract with another person. And then that other person does not know that ikaw di ay, as a non-manager, wala kay authority to perform that act. So it will still bind the partnership. But if the other person has knowledge of such fact, he knows you have no authority to act, but despite such knowledge, he still decided to enter into that contract with you, then it will not bind the partnership. Then for acts not apparently for carrying on of the usual business, so for those acts that are not within the ordinary course of business, the acts of a partner does not bind the partnership. Okay. Exception, the partnership is bound if the other partners authorized him to do the act, meaning the act was ratified by the other partners. If it is ratified, then it will bind the partnership na. Okay, acts of strict dominion. Mo ni siya kung pasabot na acts of strict ownership as compared to acts of administration. So again, acts of administration, these are acts that are usual to the business within the ordinary course of business. Other than that, we classify it as an act of strict dominion or act of strict ownership. So, okay. Should I go over this one by one? Okay, let's just go over this very quickly. So one or some of the partners have no authority to do the following acts of strict dominion. So for in these cases, since they are acts of strict dominion, they need the consent of all partners. Okay, assign the partnership property in trust for creditors, dispose of the goodwill of the business. So you actually don't need to memorize the list. Just appreciate kung bugat kayo siyang butang, no? Di siya ordinary, then act of strict dominion na siya. No, confess a judgment. Kasi pasabot anong confess a judgment? Ang kuno nimo nga naay utang si partnership. So that is bugat because it's prejudicial to the partnership. That is an act of strict ownership or strict dominion. Enter into a compromise concerning a partnership claim or liability. So for example, na nakautang ni partnership 1 million and then nakig-compromise ka, ay sige, okay ra, 500,000. That one is an act of strict dominion. Submit a partnership claim or liability to arbitration. So arbitration is actually, for example, imbis nga i-file sa court, i-file na noon sa arbitration tribunal. So that one is an act of strict dominion. And then renounce a claim, so meaning forgive. Oh, creditor, I forgive you. You cannot do it alone. No, you need the unanimous consent of the partners. So again, you may do so, all of these, if you are authorized by all partners. In a sense, nihatag ra gyapon sila sa ilang consent. No? So there is still unanimity. Or the other partners have abandoned the business such that you cannot get unanimous vote because the other partners are awol na. Una sila paki. So, okay ra nga, dili nimo makuha ang 100% nga votes. So, if you do all those things without the consent, the necessary consent, it will not bind the partnership to persons having knowledge of the restriction. So, murag same ra sa ako ang gi-explain diri nga part. Okay? We don't need to go back to that. Okay, which kanang important. This one is also understandable. You can read this on your own. Basta just remember nga, if you are the owner of the property, you have ang nai-right na to dispose the title or to transfer the title of such property is si owner lang. If you are not the owner, then you cannot transfer title of the title of such property to another person. Okay. Okay, so liability for admission by a partner. Okay, this is actually related to evidence, magod evidence nga rules ba. So for example, you admitted no a partner, ni-admit ka nga si partnership di ay naagi utang ani ni Mr. A bisag dili siya recorded sa books, gi-admit niya. So an admission or representation by any partner may be used as evidence against the partnership when it concerns partnership affairs, and such affairs are within the scope of his authority. Di kaayo ninyo ma-appreciate, no? Kay wala man gud ninyo nakitaan ang rules on evidence, but nani dito admission against interest. This is actually an exception to the hearsay rule sa evidence. So dili kay ni nato point of concern as accounting students. Kada lang marag necessary nga knowledge for the accounting students. Liability for wrongful acts of a partner. The partnership is solidarily liable with the partner who causes loss or injury to any person, not a partner, or incurs any penalty through any wrongful act or omission. Unsay pasabot sa solidarily? Ay mo kalibog sa solidarily o subsidiarily ha. Ang subsidiarily pasabot ana second priority lang ka. Subsidiary. Nay primary. Parehas ganina. Primarily liable si partnership sa partnership debts. Subsidiary lang si partners. Kani solidarily pasabot kamong duha liable mo for the full amount. So meaning ang victim can ask the full amount from either you, the erring partner, or the partnership. Solidarily liable. So you both are primarily liable. That's solidarity. Okay. Then liability for misapplication of money or property. The partnership is liable for losses suffered by a third person whose money or property was received by a partner and who misapplied it. So misapplication. Kumura na man siya og solidary liability. Now, and then liability of the other partners. All partners are solidarily liable with the partnership for its liabilities. So solidary ha, solidary. Pasabot sa solidary, makapili si victim, kinsa yang paninglan sa 100%. This is ang iyahang Yang opposite is jointly liable. Ang jointly liable, pasabot, depende sa inyong share. Dili pwede makakollect si third person sa full amount sa isa ka person. Dapat magtunga-tunga jud. Solidary, pwede 100%. Okay, this is more on law perspective, no? Law perspective. Paspasan na to kalayo pa rin. 26, hapit na alas 12. Okay. Liability in case of partnership by stoppel. You already know what we mean by a partner by stoppel. Diba? This is someone nga, you have the opportunity to contest the statement, but you did not do so. So you will be stoked. So like if you become a partnership by stoppel, you will be liable like a partner. No, but only with respect to that person who has relied in good faith. So nga imong giilad, no? So siya ra nakay liability nga person. So for other persons nga you did not make any representation, you will not be considered as a partner. Okay. So man ato ang important area. So here we have a summary of the rules. You can read that on your own. And just if you have any questions with your personal, in relation to your personal readings, feel free to raise them in Canvas. You can email me through Canvas. Then let's not concern ourselves with cooperation by stoppel because partnership naman ta. Okay. Liability of an incoming partner. Unsa gani ni incoming partner padung i-admit as a new partner. A person admitted as a partner is liable for obligations incurred subsequent to his admission, as the other partners are liable for obligations incurred before his admission, but will be satisfied only out of the partnership property unless otherwise stipulated that he fully assumes such obligation. So ang pasabot ani, di ba? As a rule, kung general partner ka, di ba, liable ka sa imong contribution plus personal assets, correct? If kuwang ang partnership assets. But if bag-o ra ka gi-admit as partner, ang imuhang liability with respect to obligations that have already been incurred before you become a partner is only to the extent of your contribution. Dili pwede di pwede magamit imong personal assets. Magamit ra imong personal assets for those obligations incurred subsequent to your admission as a partner. Kanang pag-admit sa imuha as a new partner. Okay? And then here, notice to or knowledge of the partnership, ang main takeaway ani is that knowledge to the partner is knowledge to the partnership. Okay, di ba, marag knowledge to the agent is presumed as knowledge to the principal. Okay, preference of partnership creditors in partnership property. So if ikaw creditor makautang si partnership nimo, ang property nga imong kaon as payment, mo ni siya ang imong i-follow nga preference. Okay. So here, for partnership property, ang preferred nga bayran ani is partnership creditors, correct? Okay, partnership property is to partnership creditors. For partners individual liability kitong personal assets niya, ang mas preferred nga makakuha ato is ang individual creditors sa mga partners. But if in case of insufficiency of assets, if you are a partnership creditor, so after exhaustion of partnership assets, the creditor may come after the private property of the partners. Okay. If you are creditor of a particular partner lang, and then kuwang ang iyahang personal assets, you can ask for an attachment and public sale of the share of the partner and the partnership assets. So mo siya himo ni mga collateral. Okay, and then, masabtan na ninyo. Okay, this stems from this discussion from inside. So, just remember the basic, okay? So, in my case, sulti na lang ko. Nasulti naman, na-introhan naman ako. So, kaning ako ang mga gidiscuss for partnership. Ako'y mo himo sad sa questions sa inyong RFBT sa partnership. So based on, I think, hatag naman ako, di ba, ang test map. So, 5 items only, di ba? Sa kadaghan atong istoryaan, 5 items only ang partnership. So, you can be sure na since lima raman, so I will choose those very, very important nga concepts. And then, important and basic. Okay, important and basic. You can expect that from me. Important and basic. 5 kabuok. Or partnership na question. Okay? So, muna, let's just focus on the important topics and then that are relevant to your future work as CPAs someday. Okay, dissolution and winding up. So you already know what is the difference between dissolution and winding up. I think you already have this idea naman. Dissolution is the first step, no? Winding up is the second step. Winding up is meaning inyo na siyang isettle tanan affairs, no? Gibayaran ninyo liabilities, gibaligyan na ninyo tanan assets. That is winding up. So what is another term di ay for winding up? Sige la in terms sa winding up, nga mas common na term nga to ang i-refer sa inana nga stage sa life sa isa ka entity. Correct, liquidation. So liquidation. So dissolve first and then liquidate. Sakto. So bright ka ay no. Dissolution is the change in the relation of the partners. So ang dissolution day is more siya intangible siya nga. Intangible siya nga act. No? We shall dissolve this partnership. So meaning, we shall stop the relationship. That's the solution. But then, mas tangible ang liquidation or ang winding up. Mas makita ni mos mata. Because ang winding up, magud makita na jud ka nga. Ang mga assets, gipamaligya na, no, niya ang mga kwarta, gidistribute na, gibayaran na ang mga creditors. So, muna siya ang winding up. So, okay. Kani, true or false? Winding up always happen, no? I mean, winding up is always necessary after dissolution. True or false? Kailangan ba jud na ay winding up? Ikahuman sa dissolution? Winding up is always necessary after dissolution. Is always necessary after dissolution. Answer? False. Okay? False. Kaya nga naman. Again, dissolution is merely the change in relationship. I don't want to become a partner anymore. Let's dissolve this. I want to withdraw from the partnership or someone dies. So the partnership is dissolved. But what if ganahan manghapon mo nga i-continue ang business? It's just that we will continue without that other partner because the other partner is dead or the other partner has withdrawn. So ang mga nahabilin, we want to continue this business. So we will be dissolving the partnership. Okay, again, dissolution is like intangible nga murag, okay, murag, there is just a change in the relationship. But it doesn't mean nga, ibaligya na sa tinyo tanan assets. Kay what if di ay, kainahan pa mo continue. Katong mga tao nga habilin, i-continue na lang nila ang business without that other person. There is dissolution in law, in a sense nga, mawagtang ang pangalan atong isa sa partnership name. Okay? But they could continue. So there will be no winding up in that case. Okay? Okay. So, at least, di ba, nakutaw itong uto ka, sakto di ay. At least na-affirm na to ba to ang oo, sakto di ay, no? Basin nakalimot ra mo. Okay? Kalimot ra mo. But, you all know, no? Sa inyo pang utok jud nga, pwede man day continue. Like, for example, someone died. So, the surviving partners may continue the business, but this time without the name of the other partner. So, there is dissolution per se, but there will be no winding up. So after winding up, so gisettle na nimo tanan kung for example, you really want to wind up, then mo ganahan jud like let's stop this. So you pay off the partnership creditors and then if na pay nahabilin, then i-share na ninyo, di ba? I know that you have computed that sa inyong sa kan nga AC subject, mga financial accounting subject, di ba? Katong sa partnership ninyo, di ba, na-compute mo ato, pila na share ni partner A, partner B, partner C after liquidation. So after na natanan, na-settle na tanan, then lastly is determination, is the death, your complete death of your partnership. Okay, so there are several causes of dissolution. This part is understandable. You don't need my guidance for this. Masabtan na ninyo nga, mo di ma-dissolve mo. For example, kanilang letter A, nahuman na ang definite term. So of course, ma-dissolve na dyan. Okay? So, nasabtan na ninyo diha. So, dissolution of a partnership could be classified into two. There could be without violation of the agreement, or rather three, in contravention of the agreement or by operation of law. So these parts are understandable, quite understandable. And then sometimes, ato akong giingon kanina nga, for example, a third or an assignee, if there is fraud in management, the assignee can sue you in court, and then the judge will say, this is operating illegally, or there are mga hocus-pocus diri sa inyong business. So ato ni i-dissolve ang inyong partnership because you are not operating legally. So the court can also do that. So what are the effects of dissolution on the authority of the partners? The partners shall have the right to wind up partnership affairs or complete the transactions begun but not then finished. But sometimes, diba, the partnership contract will actually appoint a liquidating partner. Sana si liquidating partner, siya si partner nga obligated to wind up the affairs. So liquidate the partnership assets, pay off the partnership liabilities. Okay, so siya tanan mubuhat ana. Okay. On liability for transactions after dissolution, the liability of a partner in general is the same as in ordinary contracts, which is pro rata and subsidiary. In the following cases, however, the liability shall be satisfied out of the partnership assets alone. So there is no subsidiary liability. That means these creditors cannot go after the personal assets of the partners. Where the partner had been, prior to the dissolution, unknown as a partner to the person with whom the contract is made. Of course, he cannot run after that unknown partner. When the partner had been, prior to the dissolution, so far unknown or inactive in the partnership affairs, that the business reputation of the partnership could not be said to have been in any degree due to his connection with it. So remember katong mga partners, katong mga secret partners. So that's one of the perks po di no, we could appreciate na if secret partner ko, pwede di ay nga dili ko madaganan sa ako ang dili ko makuhaan sa akong personal assets because in the first place, creditors do not know that I am a partner. Okay. Else, ano lang important ako i-highlight ha. Here. So for winding up, okay, how shall we do winding up? So it could be extrajudicial or judicial. So masabtan na sad nga extrajudicial meaning out of court, you can do it informally among yourselves. And then you can also ask the court to guide you in the liquidation of your partnership. And this is usually done if the dissolution itself is by decree of courts, no? So if ang pag-dissolve pa lang sa inyuhan ni agi na sa korte, automatically though, ang winding up is judicial po, di ba? Kay link raman siya sa dissolution. Okay, so after this, each partner may have the partnership property applied to discharge the partnership liabilities. Masabtan na sad, di ba? Mag-winding up na mo, ang partner, ikaw as partner, naka-right to use the partnership property to pay off the partnership liabilities. And then if napay sobra sa partnership assets, then you apply that to those owing to the respective partners. So tagaan nag-share ang partners kung nay sobra. Okay, so but if the dissolution is in contravention of the agreement, good morning, attorney. What if duha ka partners niya ang usa mo withdraw? Does it result to partnership winding up? No. You can continue as a sole proprietor. Ang pasabot mo sa winding up is ibaligya na jud ninyo tanan. Look, i-dispose ninyo tanan ba? So you can still continue as a sole proprietor, but it's just that you have to pay off the balance of the capital of the retiring or withdrawing partner. But you don't need to sell your assets, or you are not obligated to settle all partnership liabilities in that case. So if the dissolution was made in contravention of the agreement, you need to look at whether that partner was the one who caused the dissolution or not. Okay, because they have different rights. And kani magud nga part din no kaning sa winding up is accounting kaayo siya. And if you look at it like words ra jud, dili kay nimo siya ma-appreciate. And I leave this no to the financial accounting side nga katubang nag-compute hinumdum man siguro mo kanang mag-compute mo bas partnership nga pila na lang ang balance sa capital ni partner A, partner B, partner C. And then if the partnership is dissolved and liquidated, let's say ang machine or ang computer sa partnership, although recorded in the books at 20,000, was sold for 18,000, no? And then ang liabilities nato sa atong mga creditors bayran if na mahabilin, atong ihatag sa ato ang partners, no, atong i-distribute sa atong partners. So kana man gud siya nga part is more on kailangan na adyo siya mga numbers ba. So financial accounting kan siya nga part to make these provisions alive. Kailangan na ay numbers. So kani nga part is I believe you have already appreciated this sa inyong financial accounting. It's just that kung tan-awon mo siya in words, mo siya foreign kaayo for you. But in actual, you have experienced this na. No? So, that's an indication nga, maybe I will not ask a theory question from winding up. Okay, I think more on sa winding up naman ni and dissolution, which I believe is best suited na for financial accounting. Okay, so the bulk of the partnership law is on the creation of the partnership, and then it's how do you distinguish partnership from the other forms of business entities, and then the rights and obligations of the partners. Diha tamang focus, okay? Sa 5 ka questions sa partnership. Okay, next question. I just want to clarify. Do we need to study all the computations of liquidation, loss on realization, schedule of safe payments, dissolution, blah, blah, blah? Or focus on lots of theories? Okay, since this is an RFPT subject, I will not ask you to compute. Okay, so mo siya nga. Kaninga part sa winding up is could be ipangutana na siya sa inyong advanced financial accounting ba siguro na nga subject basta katong partnership, but for partnership law we focus on theories. I will not ask you to compute. Okay, so that's why I mentioned na we just focus on the creation of the partnership, distinguish partnership from other forms of business entities, and the rights and obligations of partner. Yeah. Attorney, I have a question as per the piglet scenario. Does the ownership of the fruits of the 3 piglets being transferred to the creditor at the perfection of the contract or upon delivery of the thing? Okay, so here, ayun doon mo sa inyong, question na ako balikod. With regard daw sa piglet scenario, anong doon pa mo, katong tulo ka pigs nga nanganak. Okay, that's the ownership of the fruits of the three pigs being transferred to the creditor at the perfection of the contract or upon the delivery of the thing arises. Okay, when we speak of ownership, diba, we have the real right and the personal right. Okay, so personal right is right to demand, no, right to demand the delivery of the thing. But real right is where transfer of ownership actually happens. So for transfer of ownership, there is a requirement of actual delivery. So, kumbaga, si partnership, di ba dito, sa akong example kung nakalimto mo ganina, wala man ako gi-deliver dayon ang pigs, no, niya, nanganak na lang sila. So, si partnership, naa siya personal right to demand the delivery from me. But prior to the actual delivery, the 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 ownership over the pigs and the piglets remain in me. It will only be transferred upon actual delivery. Ang pasabot ra ani siya, ingon siya diri nga, ingon si nag-ask, because it was stipulated in obligations that there is only real right and sakto mao dito akong ingon. So the following scenario means is it also all right to assume that after the demand of the creditor, the debtor can only deliver the three piglets and not the fruits. Okay. Ang pasabot ana day kay at the time when the obligation to deliver it arises. So ang due date, pasabot ana ang due date. Pag abot sa due date, na nakay personal right to demand, but the real right, which will be transformed into actual ownership, will only be transferred upon actual delivery. Okay. That's the same same rule with sales, 'di ba? Good day, attorney. This is related to losses, but is a stipulation to include the industrial partner to the losses valid? No. A stipulation to include the industrial partner to the losses is invalid. Void. Okay, so I think I addressed all questions. Any more questions? So if you have some more questions related to kaning partnership, you may message me in Canvas, or you can course through your questions to your division representative, and then si Div Rep na lang ang mo message na ko. Okay? Para mas hapsay atong communication. And then, lastly, ako sa stop ang recording. How to stop this?